A unanimous decision that just sent shockwaves through every level of Canadian government and society. This changes things. Permanently. Welcome back. I'm your host, and today we're breaking down one of the most significant Supreme Court rulings on firearms in Canadian history. The case centred on how far the federal government can regulate firearms before infringing on provincial rights and law-abiding citizens. When those 9 justices deliberated, they returned with 9 votes on the same side, a message that is loud and clear. There are 5 major impacts coming out of this decision, each affecting different groups of Canadians. The Supreme Court clarified the boundary between federal and provincial power regarding firearms regulation. The federal government holds authority over criminal law, using it to expand firearms regulations significantly. The court stated that federal authority is not limitless. Federal regulations cannot infringe upon provincial powers. Provincial governments can set their own rules regarding storage, transportation, and licensing of firearms. This ruling impacts the division of powers in our Constitution, with implications beyond firearms.
If you are a licensed PAL holder, a long gun owner, a competitive shooter, a hunter, you are probably wondering what this means for you on the ground today, practically speaking. And here's the honest answer. The immediate practical impact is not that your current obligations disappear overnight. Federal regulations that have a legitimate criminal law basis remain valid. The Firearms Act does not get thrown out the window. The licensing system is still in place. Safe storage rules that are genuinely tied to preventing harm, still enforceable. But, and this is a significant but, any regulation that was justified primarily on policy grounds rather than genuine criminal law grounds is now legally vulnerable to challenge. And there are several of them. Certain provisions around how restricted firearms are transported within a province. Certain administrative requirements tied to authorized purposes that provinces have argued they should be setting, not Ottawa. Those are now open to challenge in a way they simply were not before this ruling. Here's a real example. Think about a farmer in rural Saskatchewan. Let's call him Gerald. Gerald owns a bolt-action rifle he uses for coyote control on his property and for deer hunting every fall. He has had his PAL for 22 years. He has never had a single incident, never been flagged, never been in any trouble. But under rules that developed over the last decade, Gerald has faced increasing administrative burdens around how he stores his firearm when it's being used on his own land during an active working day. Requirements that made sense in an urban context applied uniformly across the country. Gerald always thought, this doesn't apply to my situation. And now, the Supreme Court has given Gerald's province the constitutional footing to actually say, you're right, Gerald. We'll set the rules for our context. That is a real, tangible, ground-level change for people like Gerald. And there are hundreds of thousands of Geralds across this country. Impact number 3, what this means for future laws and the provinces. This is where it gets politically interesting, because the federal government, regardless of which party is in power, has for decades assumed that firearms regulation is fundamentally federal. This ruling disrupts that assumption at a structural level, and it opens the door for provinces to become active legislators in this space in ways they have not been before. Alberta, Saskatchewan, Manitoba, provinces that have been pushing back against federal firearms legislation for years, now have a constitutional foundation to draft their own provincial frameworks for certain categories of firearms regulation. And they will. If you think those premiers were vocal before this ruling, wait until you see how they respond now that the Supreme Court has handed them this kind of legal ammunition, if you'll pardon the expression. But here's what they're not telling you in the mainstream coverage of this decision. This doesn't just benefit the provinces that want fewer restrictions. It also means that a province that wants to add additional requirements beyond what the federal government mandates has more room to do so in certain areas. British Columbia, for example, has long wanted the ability to implement stricter local rules around certain types of storage and transport in urban-rural interface zones. That door is also now more open, so this is not a one-direction ruling. It is a ruling that gives provinces power, and provinces sit on a spectrum. The long-term legislative consequence of this is that Canada is moving toward a more regionally differentiated firearms regulatory environment. What is required of a firearms owner in downtown Vancouver may look different from what is required of a firearms owner in rural New Brunswick. Not completely different, the federal floor remains, but meaningfully different in certain areas. And depending on where you stand, that is either a long overdue recognition of Canadian geographic and cultural reality, or it is a concerning fragmentation of a national public safety framework. Both views are legitimate, but the legal reality is now set. Impact number 4, self-defense, rural Canadians, and Indigenous rights. Now we get to the layer of this ruling that I think is most underreported, most misunderstood, and frankly most important for a significant portion of the Canadian population. The court's reasoning touched directly on the lived realities of Canadians for whom firearms are not recreational objects or political symbols. They are tools of daily life, and in some cases, tools of survival. Rural Canadians living hours from the nearest RCMP detachment. Indigenous communities exercising harvesting rights on their traditional territories under constitutionally protected treaty rights. Remote communities in the north where wildlife encounters are a genuine safety consideration and where firearms ownership is as ordinary and practical as owning a snowmobile. The court acknowledged, and this is significant, that a one-size-fits-all federal regulatory framework applied uniformly from Halifax to Haida Gwaii has real constitutional problems when it fails to account for these contexts. Now, the ruling did not create a blanket self-defense exception or suddenly make it easy to carry a firearm for personal protection the way our American neighbors do. That is not what happened, and I want to be very clear about that because that narrative is already circulating and it's not accurate. What the court recognized is that regulatory schemes must be constitutionally grounded and that the practical application of regulations in remote and Indigenous contexts requires provincial and territorial involvement to be constitutionally valid in certain areas. For Indigenous Canadians specifically, this ruling intersects with Section 35 treaty rights in ways that are going to be litigated and negotiated for years. The court's reasoning gives Indigenous communities and their legal counsel significantly stronger grounds to challenge federal firearms regulations that interfere with constitutionally protected harvesting activities. That is a genuine, meaningful, potentially historic shift for those communities. And for rural Canadians broadly, the ones who live 20 minutes down a dirt road, the ones who keep a rifle in the truck, not as a political statement, but because they are working in bear country. This ruling says your provincial government now has the constitutional space to regulate your reality in a way that actually fits your reality. Whether your provincial government actually does something useful with that space is a different question, but the space now exists. Impact number 5, the long game and what comes next. All right, we are at the final and, I would argue, most important impact of this ruling. Because the 9-0 decision is not the end of this story. It is the beginning of a new chapter. And what happens in that chapter depends on decisions being made right now in provincial legislatures, in parliament, in Indigenous governance structures, and in the offices of every firearms advocacy organization in this country. Here is what most Canadians don't realize about how Supreme Court decisions actually work. The court does not implement its own rulings. It declares the law. It draws the line. And then it's up to governments, lawyers, lower courts, and citizens to figure out what that line means in practice, case by case, challenge by challenge. And that process takes years, sometimes decades. What we are going to see in the near term is a wave of legal challenges to specific federal regulations that advocates and provinces now believe are constitutionally vulnerable in light of this ruling. Some of those challenges will succeed. Some will fail because the courts will find that the specific regulation in question does have a sufficient criminal law basis. This ruling is not a get-out-of-jail-free card for every firearms regulation challenge. It is a constitutional clarification that will be applied with nuance over time. Politically, expect this to become a major issue in the next federal election cycle. Any party that wants to campaign on firearms legislation, whether they want stricter rules or looser ones, now has to do so within a constitutional framework that is more clearly defined than it was before. Ottawa cannot simply pass firearms legislation and dare the provinces to challenge it. The Supreme Court has said challenges are legitimate, and in certain areas, they will succeed. And here is the thing that I want to leave you with, because it is the thing that gets lost in the political noise on both sides of this debate. The 9-0 ruling is not a victory for gun culture over public safety culture or vice versa. It is a victory for constitutional order. It is the Supreme Court of Canada doing exactly what it is supposed to do, drawing clear lines, protecting the division of powers, and reminding both federal and provincial governments that they operate within a constitutional framework that belongs to all Canadians, not just the ones who agree with whatever policy happens to be popular in Ottawa this week. Law-abiding firearms owners in this country have spent decades feeling like the legal and political system treated them as suspects rather than citizens, and Canadians who have pushed for stronger firearms regulations have genuinely believed they were doing so in service of public safety. This ruling does not delegitimize either of those perspectives. It says, we are going to sort out who has the authority to do what, and we are going to do it according to the Constitution. And that is how a country governed by the rule of law is supposed to work. So here is where we land. A 9-0 Supreme Court decision has shifted the constitutional landscape of firearms regulation in Canada in 5 significant ways. It has clarified the division of powers. It has opened the door to new provincial frameworks. It has given rural and Indigenous Canadians stronger legal footing. It has created a wave of incoming legal challenges to specific federal regulations. And it has set the stage for firearms policy to become one of the defining political battlegrounds of the next decade in this country. If you made it this far, you already know this stuff matters. So here's what I want you to do. First, if this video gave you something you did not know before, subscribe. Hit that notification bell because we cover this kind of legal and political news every single week, and you do not want to miss what comes next on this story. Second, comment below and tell me which of the 5 impacts surprised you the most. Was it the provincial authority angle? The Indigenous rights dimension? The long-term political implications? Let me know, because I read every comment and your feedback shapes what we cover next. And third, share this video. Send it to a friend who owns a PAL. Send it to the person in your life who always says Canadian politics is boring. This is about constitutional rights, regional autonomy, and the future of how this country governs itself. That is not boring. That is Canada. I'll see you on the next one.